Hello, welcome to Learning Law, and this is Company Law Part 3. In this video, we are going to see Memorandum of Association, Articles of Association, Contents and Alteration of Memorandum and Articles of Association. Memorandum of Association. Section 2, Clause 56 of Companies Act 2013 defines Memorandum of Association as Memorandum means the Memorandum of Association of a company as originally framed or altered from time to time in pursuance of provisions of this act or any other previous company law. And here, what is a real meaning or definition of Memorandum of Association is not available in Companies Act 2013. So, what is a Memorandum of Association? Memorandum of Association represents the charter of the company. It's a legal document prepared during the formation and registration process of a company to determine relationship with shareholders, and it specifies the objectives for which company has been formed. It defines what is the objective of the company for which a company is formed. A company can undertake only those activities which are mentioned in the Memorandum of Association, and they cannot act beyond the scope of Memorandum of Association. As it is a charter for the company, it defines what is the object of company and everything. A company cannot act beyond that. Memorandum of Association lays down the boundary beyond which actions of company cannot go. And contents of Memorandum of Association are name clause, registered office clause, object clause, association clause, liability clause, capital clause. Name clause includes the name of a company, and there are certain conditions for name of company, as a name of company should not be identical or resemble to any of the existing companies, and it should not be an undesirable name to the central government. And object clause, association clause includes the persons who are subscribing the company at the time of incorporation. They are that are mentioned in association clause. Liability clause, which includes unlimited liability or limited liability, that are mentioned in liability clause. And capital clause. Alteration of Memorandum of Association. Memorandum of Association can be altered. How? Alteration of name clause. By special resolution at general meeting and permission of government, new incorporation certificate is issued. For alteration of a name of a company, it should alter the name clause in Memorandum of Association by passing a special resolution at general meeting and with the permission of the government. After that, new incorporation certificate is issued. Alteration of object clause. The company has to call a general meeting of its members and pass a special resolution and file a certified copy of resolution with the central government, and other prescribed procedure has to be followed for alteration of object clause. Another information is, for alteration of object clause, the capital which is collected, which is raised by issuing prospectus, has to be dispersed. When there is an undisbursed amount with the company which is raised through prospectus, then alteration of object clause has a different procedure. Alteration of registered office clause. A company may change the situation of its registered office for smooth running of its business and the realization of its objects. Such change in situation can be, there are of three types of alteration of registered office procedures has to be followed, and shifting from one place to another in the same city or town. If a registered office of a company is going to be shifted from one city to another city of the same state, then the procedure has to be followed is, board of directors passes a resolution and gives the name, address of its registered office, that is new registered office, to the register within 30 days. Then the alteration comes to effect. If the shifting of registered office from one town to another in a same state, one town to another, then in this type it has to pass a special resolution at its general meeting and send the notification to the register within 30 days of passing, and after that new address is altered. If the shifting from one state to another, it includes a large procedure. First, it has to pass a special resolution, and second, the confirmation has the company law board has to confirm the alteration of its registered office from one state to another, and then objection has to be raised. If any person interested objects, the objection has to be inquired. After that, the alteration comes into effect. After the permission of central government, alteration of registered office of a company comes into effect. Articles of Association. Article of Association form a document that specifies the regulation for a company's operation. The document lays down how the tasks are to be accomplished within the organization, including the process for appointing directors and handling of financial records. An article of association is always subsidiary to the memorandum of association. It's an important point as articles of association cannot go beyond the scope of memorandum of association or violating the memorandum of association, as alteration of articles of association is subsidiary to the memorandum of association. Contents of article of association are amount of shares, capital value and type of shares, right of each class of shareholders regarding voting, dividend and return of capital, rules regarding the issue of shares and debentures and procedure regarding call on shares. It specifies the duties, rights and powers of management of company. Alteration of articles of association. Company can alter its article by way of addition, deletion, modification, substitution or in any other way. To alter the articles of association by giving notice of at least 7 days on board meeting, the board meeting it has to recommend the proposed alteration to the members, and then by passing a special resolution in the general meeting, the articles of association is altered. Next, binding force of Memorandum of Articles of Association. Section 36 of Companies Act 2013 states that when Memorandum and Articles of Association are registered, it binds the company and the members the same way as if each member and company have been respectively signed the documents. Articles of Association and Memorandum of Association is binding to all members of the company as they have signed the document. So it's binding to all the members, directors and all those persons concerned the company. Thank you for watching this video.